Yes, Lordship, I have filed in IA, my lord. In earlier occasion, yes, due to my mistake, my lord, it was already.
Please give to the court master, let them adjust the dates because there are a lot of
Lordship.
pressure on the bench right now.
On 23rd, my lord.
He'll take a call. Any prayer for listing, give it to the court master.
May please, your lordship. Sir, I get to mention item number 7.
4,
7.
7.
Mr. I. Hussain is out of station, so it may be adjourned for only 1 week.
Okay, after a week, I spread for bail and counsel for the petitioner. Also, is a representative.
Yes.
Mayor, please, your lordship. I like to mention item number 26, your lordship. The engaged counsel Mr. K. Masan is out of station, your lordship. Kindly matter will adjourn after 1 week.
Okay.
For 1 week.
2 weeks.
Yes, your lordship.
Item 26, 2 weeks. What says it?
Oblige.
Yeah, please, your lordship. I beg to mention item number 1 and item number 27.
1 and 27. 1 is an old matter.
Personal.
Just wait.
And
That was an
item
18
number
matter.
27.
And
7.
27. 27 matter. 2 weeks.
May I please, Lord? I beg to mention item number 35, my lord. I on behalf of J. Islam, my lord.
Okay, 35, 2 weeks.
May please. I beg to mention item number 17.
17, 17.
17. Kindly pass over for the week.
Okay, 2 weeks. 17. Okay.
Oblige.
Lordship, I beg to mention item 25, my lord. It may be adjourned for a week.
It goes for 2 weeks.
Oblige.
25.
May please. I beg to mention item number 31. And it adjourned for 3 weeks.
Same order. 31.
Oblige. May please, your lordship. I beg to mention item number 38, your lordship. But its matter may be adjourned.
37 is an orders matter. Why it has come for orders? It's a review petition.
Yes, your lordship.
Let the matter be called. It's a review matter. Let the matter be called.
Please, your lordship, I beg for item 44. Item number 44 for adjournment.
44.
As my senior is incapacitated at the moment.
It's a criminal writ petition. Hmm? Oh, yes. Okay. Both sides are represented as the counsel for the petitioner on record is in bereavement. The matter stands adjourned today. List after 2 weeks on a date to be fixed by the office.
My lord, I beg to mention item number 8, my lord. In this case, my lord, the petitioner is expired, my lord. So I think, my lord, matter may be infructuous, my lord. At the point of time, he was 73 years old, my lord. Due to old age, my lord, he is expired.
You want an adjournment?
No, my lord, may I pray
It will
for
close.
close, my lord.
Okay. Also, it's represented. Mr. A. Ali, Learned Counsel for the petitioner, submits that he has received instructions that the petitioner, Abdul Adud, has expired due to old age. So accordingly, he has instructions not to press the matter. Prayer is allowed, the matter stands closed. As the petitioner has expired. You have a date of his expiry?
My lord,
Date of death?
date, my lord, I have forgot, my lord. Earlier, my lord, I was told.
Okay. Yes,
May I please your lordship? Lordship, item 36. Lordship. Okay, my senior.
36 is,
Will help
okay.
my. Pass out for the day, madam.
Okay, it goes for 2 weeks. 36.
Almost.
We are calling up orders matters first, wherever there are correction of orders or miscellaneous matters, but not bail.
Item 38.
May I please your lordship? Lordship, the youngest counsel is out of station, your lordship.
Just a moment.
He instructed me to adjourn the matter for a week, your lordship.
Record qualification. Attendance to exam to website.
At best, one for a record if required. Or we wait until the matter they are. We have not even purchased. Even ordered 1711. Report. Round, they say. It's like. Criminal. We are calling for the records. This is hard Joint Council for the parties. By order dated 17/11/2022. Is what? Had, while considering the review petition, permitted the petitioner to remain on bail. Stop. Considering the issues raised, this court is of the opinion that the relevant records would be necessary to decide the issues raised in the petition. Stop accordingly. Registry will call for the records of FT Borpeta FT case number 70 of 2016 from Foreigners Tribunal 10th Borpeta. Stop. Matter be listed after the registry receives the records.
Highly obliged.
Item 42. Item 39 with 40.
Yes, we don't Lordship passing for a time.
Lot.
Was any judicial inquiry conducted
But in
or
item,
ministerial inquiry?
yes, my lord. In the next item, item WP criminal number 6 of 2022, there, there, my lord, the affidavits have been filed.
Is the postmortem report available to see the ligature mark?
Postmortem report is there. In the petition. So in WP criminal 6, my lord, page number 47, my lord. Yes, lord. The ligature mark lordship will find at page number 51. Mark of ligature. Annex 8.
But this is incomplete.
But
You'll find it page 55.
page number 35, my lord.
55.
55. Yes, my lord. Till the report of the FSL. Opinion regarding cause of that is kept pending till receipt of the report of the chemical analysis and viscera.
That's 21.
Yes,
I think it should have been here by now.
yes, it has come, my lord. It has come. My lord, the judicial report is page 86. It is a part of the affidavit filed by us, my lord. Annexure 2, page number, running page number 86.
Page number?
Page number 86. Matlab, there is a affidavit filed by Sanjeev Kumar Setia,
Yes,
response number 5
yes.
on 12/9/22. Kindly come to annexure 2, matlab, page number 86. By Judicial Magistrate, first class, Borpeta.
Why very half-heartedly drafted affidavits? This document is a part of paragraph 5. And paragraph 5 you have verified as partly to the records.
Lordship. Some allegations have been denied.
No, I understand, but you see, partly means what? The document is whether part of your affidavit or you have excluded that, we don't know. Which part you have not said.
Lordship. I'll take care.
It's a criminal petition, we have to see the affidavit first. And postmortem, you are required to do it under video photography. Where is the photograph of the dead body? Because you're saying that it's a non-continuous ligation mark.
Lordship. But
Can you tell us this annexure 2
Lordship.
is by a Munsif from judicial magistrate, first class.
Yes, my lord.
How was he deputed to be a part of inquiry? In what manner this, he must be entrusted with the inquiry.
Well, under the provisions of the CRPC, no?
No, I understand, but there must be, it has to be a district judge.
The territorial, the magistrate concerned of that particular territory, territorial jurisdiction, he used to make the inquiry, no? Under 176, no? Yeah, CRPC, no, no. One 74, 176.
Criminal procedure code दिया ना? Criminal procedure code.
दोनों तो दे
Yes, yes. Look, section 176 of CRPC.
Yes. We will require the photographs to be produced.
The other, there is a reference of videography, page 85.
Page 85.
Page 85 of that same affidavit. The third last para, last sentence. After completion of postmortem, the dead body was handed over to the family. Videography of postmortem CD on 13/10/2021. There it was done.
85.
Page 85, Annexure 1.
No,
The
that's-
executive,
no,
the
please.
report is at page 86. I'm referring to page 85 now.
Your affidavit of Sanjeev Setia
Madam,
in our record begins at page 83.
83.
I'll.
And
Then-
Annexure 1 is a detailed report.
Is a detailed report. I'm referring to that only. I'll make correction of the page numbers. This Annexure 1 I'm referring. The last,
Or something under videography.
yes, Lord. Third last para, last sentence. CD was there. If Lordship directs, I'll try to
And
collect.
where is the inquest report?
Inquest in the same affidavit, kindly come to the last, second last page it starts.
Yes, 99.
Page-
Sorry, 99 is the,
101 was possible.
it is in our copy, it is inquest is 104.
Correct. अच्छा, एक पेज नंबर बड़ा करेक्ट हो लेगा। एक कैसे तो मैंने पेज नंबर फोटो वाला मिला है।
I think the postmortem report, the completion of the postmortem report is also necessary.
Yes, yes, my lord. My lord, that subsequently, my lord, we have brought it to record.
Hmm.
On 10/11/22, we have filed an affidavit, my lord. There, my lord, annexure A, annexure A, it is there, my lord. This affidavit is filed by Amitav Sinha, my lord, SP Borpeta. 5/11, 5/11, my lord, 22. Sorry, it is 10/11/22.
Page number.
But I have recorded page number as 101, it starts, maybe 103. I'll make the corrections in my page numbers. The final opinion of the doctor is last page.
Amitav Sinha.
Amitav Sinha. Annexure A, the communications from the
Rejoinder affidavit filed on 14/2/2023.
No, my lord, on 10/11/22.
Yes.
Annexure A and onwards, kindly see, my lord.
What is the rejoinder affidavit?
Filed by Amitav Sinha, my lord. But in fact, during course of hearing, petitioner has made a submission that the position of the toilet is such, a person cannot commit suicide, and the other persons, other inmates, they will just see if somebody has done something, and so honorable court has directed us to apprise the position of the toilet, how the toilet is, what is its position, my lord.
No, but that apparently is not very convincing, because somewhere we read here that in fact, in that report by the judicial magistrate,
Lordship.
there you will find that he has given a description that in the toilet there is a what do you call ventilator that has 2 iron rods, and after this inquiry on 21/10, they had sealed the ventilator with a aluminum or something sheet. So that means on that day, when the suicide was committed, the ventilator did have two iron rod where it is possible to commit a suicide. But that's why we were searching in your inquest report. Nothing is given as to the situs where where the inquest took place. The inquest is 4 p.m.
4:30, my lord. They said
So
because
place of inquest is not given.
place of inquest.
That is why we required that photograph of the
Four-
position of the dead body while hanging.
Got it. Place is given, my lord. Page A, bathroom of,
No, where it is found. That is the place where dead body is found.
yes, my lord.
Where the postmortem, where the inquest was conducted. There's a difference between place where the body was
Body was found and the
found
inquest.
and the place where inquest is conducted.
তাতেই করে তাতেই করে এরকম। Place there said district jail Borpeta, second page.
No, that means the situs is different from where the from where the dead body is found.
Bathroom,
Inquest is somewhere else.
in the bathroom, it was they found the body.
You see, we want to just
Logic.
have an idea.
Logic.
Number one, the position of the dead body. Then comes the next stage where the inquest would find the first evidence of the nature of injury on the body or condition of the body.
True.
Then third comes the what you call postmortem.
True.
Then we are correlating
True.
as to the cause of
Death.
probable cause of death.
In the district judge, they brought down the body, and the district jail they have done at last phase place they have mentioned as district jail Borpeta.
Yes.
But where that photographs exactly Lordship have pointed out, I'll try to place it. I'll try to place it.
Now you understand perhaps because the position of the dead body scene, if it is different, that means it has been brought down lying. So we want to see whether any evidence has been lost in the process.
Well, the photographs has to be there.
Has to be there.
Has to be there. they hanging position photograph. Otherwise, without photograph, they will not brought down the body.
No, that's what we.
So ordinarily, what my learned brother is
Malad.
making an inquiry that you are supposed to have the inquest there itself,
Lordship.
place of occurrence.
No, possibly in the bathroom, possibly. I'll just verify. I'll verify. Because they have said as
No,
district
they
jail.
will, you see, you are right. It may not be there. But then when the body is brought down, there must be some note somewhere to say that the body has been brought down. What was the process of bringing down? Whether the issue is whether any evidence was lost in the process. Definitely, when you find a dead body in the early morning, till 4 o'clock, you will not keep a dead body hanging like that. It is inhuman. So definitely they will bring it down. But is it documented? Is it? Do we understand that there is no evidence has been lost in the process?
Malad. I'll verify. I'll verify. Yes.
Let them try to-
Additional affidavit.
This before. Is 118.
It will relate something. Not to your person.
It's not evident.
My esteemed brother has found out, page 118 is a photograph, but it does not show annexure A to affidavit in reply. This affidavit in reply is filed on 5/12/2022.
Yes, my lord. This is a photograph after possibly the body has been handed over. The other persons are
But
standing.
here in the mandible area, we find that injury is there, injury mark is there, but neck we don't find.
Uh,
That's why
clots are there.
those are there.
Clots are there.
Some blanket. is put
Blanket.
up.
The other persons are standing there. my lord. When the body was handed over to them, possibly after that, my lord.
We bring those photographs on record.
I'll-
We just say that you are exploring the possibility of whether there is any photograph available and to bring it on record.
Lordship.
My lord, I have two submissions at present.
Yes, yes.
Lordship has called and they will produce and Lordship would examine that. But my present prayer is this, my lord. It is the incident of 2021. And the petitioners are the oldest father and mother.
No.
After all, the incident took place inside the jail. And the deceased was in their custody. And so far in respect of Ray, in Ray inhuman conditions in government, these two citations. Here almost all the important citations of the Honorable Supreme Court has given. What my learned friend has desperately tried to shield the officials from their misdeeds. So these two judgments, I have so many judgments, but this judgment has covered all the matters. So
No,
first,
but you see this,
today my limited submission would be, my lord.
No, but you see, once you are citing this inhuman conditions of 1382 prisons, then for to invoke this principle laid down here, the first and foremost issue is there must be an evidence of custodial violence. Number one. Number two, it has to be a case where the death is not suicidal, but it is homicidal. That apparently the records which are here doesn't show. So ultimately it boils down to only one part, whether the court can grant compensation in such cases. That is the only question to be
My lord,
decided.
my lordship is correct, but thing is this, even if it is a suicidal case, even then they are responsible.
No, that's okay.
Because
but we'll have
the
to, you
incident
see,
happening within
even-
their custody.
No, even in order to give a interim compensation.
Firstly, we do not admit this. All are their concocted stories to
No,
shield
that
up
is-
their
that is
officers.
that is the point. Even to order an interim compensation, we'll have to record a statement as to whether we prima facie find it to be suicidal or
That from
homicidal.
the very beginning, my learned friend also we are praying that district session judge Borpata may be ordered to expose inquiry. But till today that has not happened.
Where is the body?
Body is now in graveyard. And first thing, when the suicide took place, and we came to know about this, we wanted to see the dead body, but we were not allowed. We are
No,
not
but
allowed.
Apparently, the dead body is handed over to the family member.
No, that has been handed over after postmortem. But immediately when the news of alleged suicide has come, we want to see the body, but our body was not shown to us. So many persons went there, body was not shown. Before that, an incident took place. Ferdous Ali, who is the respondent here also, his daughter was kidnapped by Hasibul Islam. And this Ferdous Ali is a very, very rich man. In Borpara district, he is a very, very rich man. And there is a CCTV camera, my lord. on that particular day, there was no CCTV camera. But before that day and after that day, there was CCTV camera. So there are so many circumstances which directly point out their guilt.
Without any basis.
So my prayer at present is limited. Even if it is a case of suicide, though we are not admitting at all, even then they are entitled for compensation as per government circular. And so for second part, the dereliction of duty of the government officers and their conspiracy in this case, that may be ordered
see,
by.
Incidentally, the point which I'm trying to understand is that even in this inhuman condition, you see the element of a prima facie case against the state has to be determined even for a interim compensation. You see, number one, whether it is a death which is homicidal in nature, then as per this judgment, it's a case where the determination has to be made regarding the what you call public law remedy for compensation. Now, this has two facets. Number one, compensation on loss of life would otherwise be covered by the government circular of 2016. If it is death, and compensatory what you call pecuniary compensation must essentially have a finding that it is a case of death which is homicidal in nature. Without that, we don't think we can pass an order unless we determine that it is a death which is homicidal, or prima facie it leads to a conclusion that there must be some police brutality or an assault.
Lordship, with due respect, prima facie is that the person was killed or died in their custody. That is prima facie. Not more prima facie is not necessary. That is prima facie, because this latrine is also within their vicinity. So that is prima facie. For instance, Lordship, what judgment I have given, kindly see para 53, my lord. 53. The case law indicates that over the last several decades, this court and almost every high court has relied on Article 21 of the Constitution and thought it appropriate to compensate the next of kin for an unnecessary custodial death. The constitutional courts can go on delivering judgment after judgment on this issue and award compensation. But unless the state realizes that custodial death is itself a crime and monetary compensation is not necessarily the only appropriate relief that can be granted to the next of kin of the deceased, such unnecessary deaths will continue unabated. Therefore, what is needed is a review of all the prisons with a humanitarian nuisance. Now, directions, Lordship, kindly see page 57. We are of the view that on the facts and in the circumstances before us, the suggestions put forward by the learned amicus curiae and learned counsel appearing for the National Forum deserve acceptance, and therefore we issue the following directions. The Secretary General of this court will transmit a copy of this decision to the Registrar General of every High Court within
Mr.
1 week with a request
Mr.
to
Mahmood, you are reading from paragraph 53. Please come to paragraph 45. I'm not going on other paragraphs. Come to paragraph 45 at page 12. Turn over to page 12. The portion you have highlighted.
Para 45.
Yes, the next page.
In DK Basu.
Next page which you have highlighted for us. You look at that. First paragraph says vicariously liable. Second highlighted portion. Assessment in compensation, the emphasis has to be on compensatory and not on punitive element.
Yes.
Third highlighted portion. Compensation in public law jurisdiction is without prejudice to any other actions so and so. So therefore, and it further says, with respect to the same matter or the tortious act committed by the functionaries.
Yes.
Correct. So there must be a tortious act to entitle you to compensation under the public law remedy. Then please come to paragraph 47.
In
In
addition,
47, there are about 12, 13 cases cited here.
yes, so many cases.
A, Nina Ranjan Pillai,
Yes.
here it was wrong treatment. B, Keval Bhai, victim was shot dead by a constable. C, Veduki Buragohai, unnatural victim died under suspicious circumstances.
Okay.
And death was asphyxia as a result of strangulation. D, Madhuben Adesra, the deceased was brutally tortured by police. E, Banalata Dash, deceased was found hanging from a tree with his hands behind his back. F, Amandeep, deceased was assaulted. G, Rohini Lingam, victim was murdered.
By co-prisoner.
H, victim was tortured. I, victim was an advocate held guilty of contempt while he was undergoing sentence, he was severely beaten up. J, victim died in police custody on account of use of third degree method. So you see, wherever we read this judgment, this is something we have,
Circumstantial evidence.
please try to understand. This is a judgment we have read many times. And unless there is a finding, categorical finding that it is police brutality, we think
Police brutality means police is a part of conspiracy, my lord. Brutally, they have not done this. They have caused harm to others.
No. That means you see, conspiracy must be with some person.
Yes, yes.
That means the deceased is the person who has entered into conspiracy.
My lord,
Police has entered into conspiracy with the deceased. No, that's okay. But please let us understand the concept of conspiracy. Police will enter into a conspiracy with the deceased by virtue of which the deceased will hang himself.
No, with Firdous Ali, whose daughter was kidnapped. And that is why, my lord, the CCTV camera of that particular day was not there.
That's okay.
This is very important. That is very suspicious.
Okay. But I think
Earlier day
to-
it is there, next day it is
Sorry
there,
to-
but in that day, my learned friend is shielding his officers in a very desperate manner.
No, please don't make personal insinuation. Mr. Nath is not here.
No, my
To
learned
answer
friend, I mean
in his
state.
personal,
I mean state, my lord.
No.
I am not against Mr. Nath, I
No.
mean the state.
We will see. Let us have the affidavit first. Because we are not convinced without making a prima facie finding as to what
The
will be
lordship may
nature of
kindly direct the
compensation.
district judge to cause an inquiry and
No, let us-
submit a report in a particular time.
Can I reply to this affidavit and bring it on record?
Lot, I'll file it.
Heard Mr. M.U. Mahmood, counsel for the petitioner, learned counsel for the petitioner. And Mr. D. Nath, learned senior government advocate, appearing for the respondents. Next person. The learned senior government advocate prays for some time to explore possibility of finding out photograph of the deceased while in a hanging position and to produce the same. Within 2 weeks.
Lot.
Please take a date, give us a date.
Simultaneously, district judge may be also ordered.
No, inquiry, you see, we'll have to, we'll have to
Because
go deliberate.
this type of thinking they have taken so many times for
No, no.
clarification, etc.
You see, 2021, dead body is not there. So ligature mark is the only thing which we can find the cause of death. It's not available. So other inquiry would be just, it's a superficial inquiry. It may not be necessary for the purpose of determining compensation. But we still will have to think over. A judicial inquiry must be with a privacy finding as to what we are suggesting to the, what,
Actually, I am
What is
saying,
our,
well, we do not believe them.
no, that's okay.
We believe the judiciary.
No, that's okay.
So
But
simultaneously, that
But
may be
kindly,
also.
kindly have it on 6th of November.
6th of November.
On the compensation part may be considered, my lord, that,
List on.
because for that, prima facie is
11,
not necessary.
2024. Give us some time, we'll deliberate. We are returning back your citation.
Yes, yes. I have given it.
We have a copy here in the record.
Lot.
Next item, same.
Next time, same.
Same.
For both items, make a common order.
Item 41.
Forty-one.
All of the plans. inter alia, comma, stating that even after taking effective steps and long investigation so far, the whereabouts of the victim could not be found out. And that he would be taking steps to find out the whereabouts of the missing person. Full stop. The said forwarding letter as well as the report dated 16/8/2024 is kept as a part of record. Next para. The state police shall make an inquiry at the house of the petitioner about the as to whether the whereabouts of the missing person is known. Next para. In the meanwhile, the court is inclined to grant inclined to direct the state police to obtain updated status report of investigation at Chennai after expiry of 2 months from the date of this order. Next para. List on list on 6. 24. We have a generic calendar. Come to if you say is Tuesday. It was sector. 6/1/2025.
Lot. All right.
Item 42.
Mr. Nath, this 2 months falls within that Christmas vacation. That's why we are
Oh.
extending the time.
2 months is the last day.
So
Lot.
that's why
Lot.
we are
On 6. All right.
May I please, Your Lordship? Your Lordship, I beg your apology. Kindly the matter may be passed over for the day, Lordship.
just a moment.
Another opportunity. Page number 10. That's the only.
Okay, but next time you have to do it. No further adjournment. Both sides are represented. Matter stands adjourned on the prayer made by land counsel for the petitioner. This being a review matter, the petitioner shall take note that petitioner and her counsel shall take note that no further adjournment shall be granted on the next date of listing. List after 2 weeks.
Okay.
43.
My lords, this matter may kindly be taken on Friday, my lord, or next day, any day. Next
It
week,
goes after 2 weeks.
worship.
After 2 weeks,
It is a long time. As your worship desire.
List after 2 weeks. Or both sides are represented. List after 2 weeks on the prayer made by counsel, learned counsel, the petitioner.
Item 45.
None appears on call for the petitioner. All the respondents are represented. For answer justice, the matter stands adjourned today. List after 2 weeks.
46.
May I please your lordship, my senior is on legs in court number 18. Kindly pass over the matter for time being.
Time being. Okay.
Forty-seven.
Well,
Victim is not yet recovered.
it is, she's recovered. No?
She's recovered.
She's recovered. A report is with us.
Oh, much.
Uh, But she was recovered on 7th of August, and this report came on 8th of August, Malad. That is why in the last, Malad, the present status of the case, second page, as number 2, point number 2. serial number 8 and serial number 8 she was recovered on 7/8/24.
That's the only source. But even that is the only place. I think the problem.
There's no representation from the petitioner when the matter is called. Next, Mr. D. Nath, the senior government advocate, has produced a copy of report dated 8/8/2024 from the Superintendent of Police, Udalguri, and it is submitted that the victim girl who is the daughter of the minor daughter of the informant, alleged to be 15 years on the date of occurrence, has been recovered on 7/8/2024, and the victim was likely to be produced on the next working day before the court at Udalguri before handing her over to the complainant. Full stop. Accordingly, it is submitted that as the victim is recovered, or the matter be closed. Next para. Be that as it may, as the petitioner is absent on call for injured justice, the matter stands adjourned today. List on after 2 days, 2 weeks, give a date.
The report may be kept on record.
The said report is kept as a part of the record.
Follow.
13/11. Oh, next day 13/11. The list item 1 for motion.
Yes.
Yeah, input order is at page 50, Lordship. The learned trial court discarded my citizenship certificate because I have no linkage with the with my father.
You've seen the records?
No.
You go to it. But what is the document to connect you with your projected father?
Lordship, page number 24, PAN card.
So these are all post inquiry documents.
Annexure 3 is a marriage certificate, page number 25.
You see, this reference was made against you in the year 1998. You must show some document prior to 1998 where you are shown as the daughter of the projected father.
Actually, Lordship, I need some more time because perhaps she has got some documents. I could not contact the petitioner actually. Means 1997, she has been, her name, D was included in her voter list. Actually, at the time of filing this,
Just a moment.
Mhm.
Your marriage certificate, did the Gram Panchayat secretary come and depose? Was he examined?
No, Lordship.
That certificate goes.
Oh, one more thing, Lordship, page number 31, that is 1997 voter list. At the time of filing this WS, we could not annex that one
1997.
voter list.
That's okay. 1997 again is a post.
No, actually, perhaps after that, perhaps she has, but I could not. I need some time so that I can talk to the petitioner to get the subsequent voter list.
You see, that doesn't help you. If you are referring to 1997, it doesn't help you. Come to page 50, paragraph 2. 1997 voter list has been discarded by the tribunal, giving reasons. So placing the same document doesn't help because this is part of record. It will be available there. So if you want time only for that, you already have the document 1997.
No, Lordship, I could not exhibit that time. Because
No,
Lordship,
that is okay. You see,
but
we have the document. If
no,
you
Lordship,
can-
the page number 52, the Learned Tribunal mentioned that in the reference, the OP's names were recorded in 1997 for which this D case, but prior to that, OP's names was not entered in any document since born, that is 1962, 63 to 1997.
Correct.
Since I could not annex that one, 1997.
No, that is accepted that in 1997 your name is there. That is the voter list where your name appears as D voter. That was not accepted by the EVO and therefore inquiry was made. So even if that document is there, doesn't change the position. You have to show us something by virtue of which prior to the inquiry, there is some document to connect with your projected father.
Because my father expired in the year 1969, Lordship. So that's why my father could not cast his 1969. Father expired. After the death of my father, I was after after 1 year, mother also expired. Thereafter, I could not. I was as born and brought up by my another distant cousin. So that's why I could not.
Whose document is there on page 34?
That is the documents of a child,
Huh?
elder son.
Your brother,
Yeah, no. My son.
your son.
Mm.
No, I don't think it was exhibit 3.
27.
No. Page 23. But this problem, even if we accept your contention, how can we help you? The just a second. Because this you have not introduced in your written statement the death of your father, death of your mother.
There is nothing noted.
Those things are not there. So in a writ petition, we are bound by the records which are available before the tribunal. We can't take into cognizance any document which is not there. Okay, say all sides are represented on the prayer made by learned counsel for the petitioner. Matter stands adjourned today, at least after 2 weeks. Next, it is made clear that on the next date, the matter shall not be adjourned.
Item 2 for motion.
MP Noda page 27, 28 madam.
Mr. Sharma,
Lordship,
you have checked the records
Lordship, I don't check. Lordship.
because the finding we are not very satisfied.
No.
The manner in which his finding is made. That's We'll take a short break and come back.
Yes, sir.
They came in 64, that is recorded.
Yes.
They left for compelling reasons. That's something out of the blue.
Not it. Two-line evidence on affidavit. There is nothing explanation at all. And in cross part, my lord, he said he is, my lord, aged about 35 years in on the date of cross-examination. And that is in the affidavit also, he has said he is about 35 years in 2016. Now, my lord, the document which my learned friend has exhibited, the client, the
No,
particular.
you see the finding, Mr. Payang. We are interested to know.
My lord, ignoring that part, I have understood, my lord. Ignoring that part, my lord, even though they were in India, because he is claiming that, my lord, he is the son of this, my lord, person who came in 1964. After 1964, my lord, 2014, 13, there is not a single document, either of his parent or of the petition. That is
No,
first
no.
issue.
Mr. Payang, we have asked this question many times. You see, where is the requirement? I'll say something, what do you call? My examples are always horrible. So one of the horrible
I
examples,
understand, my lord.
you see, I charge you, since I did not see you in the vacation, I charge you of visiting a foreign country and then charge you with disproportionate income. Just because I did not see you, I jumped to a conclusion that Mr. Payang had gone to a foreign country, spent millions, and therefore I charge you of evading income tax, and therefore I charge you saying that you have disproportionate income.
That is understood, my lord. What your lordship is asking, my lord, I understood. My lord,
So
only
therefore,
thing-
if
yes,
that part is not introduced,
my lord,
to
64.
arrive at a conclusion, it is a judicial finding.
Yes. That
Quasi
is
judicial
probably
finding.
that finding, even though that is construed, but accepted that it
But
is
then
wrong.
you please tell us, where is the requirement of, in that example which I gave, where is the requirement of Mr. Payang reporting to us that you are in Guwahati? And in the absence of your reporting,
I'm explaining that only, my lord. 64, he came, my lord.
no, in
And-
64, this law was not there, that one has to
No, no,
maintain
no.
a document
My lord,
of
in
continuous stay in
64
India.
document, petitioner is not there, my lord.
Huh.
Petitioner's name is not there in that document. That is what that point I want to point out, my lord. 64 document, petitioner is not there. He's claiming that the person who came in 1964 is my parent. Now the petitioner has to prove, my lord, apart from the opinion, but opinion probably, my lord, the opinion the learned tribunal had committed error. So even though, my lord, we accept that that is an error, then also, my lord, the petitioner has to prove that the person who came in 1964, those are his parents. To that aspect, what evidence he has adduced? Only that effect, my lord. Even though the person is there, my lord, he has to claim that he is claiming that that person is my parents, are my parents. But, my lord, he has not given any evidence. One aspect, my lord, that's why, my lord, he is born in if he is 35 in 2016, he is born in 1981. Up to 1964, all siblings were there, along with the parents. He has suddenly come after 20 years, 18 years, about 18 years he is born, suddenly. Can it be, my lord, acceptable? Other siblings are there in 1964, 64, my lord, that document. They are 10 years, 6 years, 3 years, 1.5 years. And now this person is born, my lord, has born after, my lord, 18 years. No, my lord.
That is good. But you see, number one, now we keep a track of the birth of a child, maintenance of its what you call records of vaccination, results of nursery, KG, class 1, class 2, class 3. Now we maintain. But if you come to my house and search, perhaps
There is
after my birth certificate,
I'm not saying, my lord, birth certificate is
the next
required.
certificate which I have is matric
My
certificate.
lord, that is his statement. He has stated.
No, that's okay.
I am
But please tell
35
me,
years.
if I am being accused of being a foreigner, please tell me, how would I connect myself with the gap of my date of birth
My lord, my suggestion will be,
and my metric certificate I have in 1983. How would I connect?
my lord, at least at earliest document, whatever your lordship have.
No, that's why
earliest
please tell us. You
the
see,
earliest
in
documents,
this
madam-
document, in this age gap, and there may be hundreds of persons like me.
Yes, definitely. my lord.
After maybe people may not have proof of birth, and the metric certificate is the only one document which connects.
Yes.
Now, if there's no cross-examination to even this 2-line evidence, if there's no cross-examination to demolish that she is the daughter of X, then what is the purpose of a cross-examination? What is the purpose of an evidence? If the tribunal has to do that finding, have this removed, that one has to file an evidence. And under which logic, if there's no document of 20 years, one becomes a foreigner.
My lord, my submission was that, my lord, the evidence given by the, my lord, the proceeding, how far it is trustworthy, because he has himself said,
No, please come to the opinion. Tell us how the court found it not trustworthy. Pertinent to mention that out of total documents produced and exhibited, though it indicates that parent of OP, including his elder brothers, have stayed in India since 1964 itself. But it is absolutely not clear from the records as to whether they came to India to settle here permanently or not. Now, intention in a civil proceedings, quasi-judicial proceedings, intention to settle or not.
that part is not necessary at all, my lord.
Then there is vast gap between exhibit 1, 2, and 4. Whose total gap appears to be almost 25 years.
My lord, 1 and 2 are the documents, my lord, which is exhibited.
That's
by the-
okay, but 25 years.
Yes.
Is there any law in this regard that if continuity of 25 years is there, then the documents become untrustworthy?
Probably that is not, my lord. The requirement is that he must be an ordinary resident of India, my lord, after entering into Assam. Since entrance. Since the date of entrance, my lord, he should be ordinary resident of Assam.
You see,
And why don't we fix the matter for hearing, my lord? We need some details hearing on this. The earliest document after 1964 is 2014 voter list, madam. Then the school certificate obtained in 2015
Also,
You
there is.
could have arrested the headmaster or principal who has given that certificate. State has immense power. If it is false, you arrest your headmaster,
That is a different issue, my
throw
lord.
him into a prison, forget the key.
In fact, in some cases, my lord, this honorable court has directed CID inquiry in almost 11 to 12 cases.
You make that submission to before us, we'll record it. Because then you see, it's a two-way traffic. Once we do an inquiry outside the scope and ambit of the tribunal's order, then we accept your contention and then we'll have to accept the contention of the petitioners also. An inquiry outside the scope of the opinion can be made by the court. Will transgress from a writ court to a fact-finding court.
No, that is in a different proceeding. my lord.
Division bench of this court has held that the scope and ambit of the inquiry in a writ petition must be within the four corners of the opinion.
Yes.
We can't traverse beyond. So if the state makes a submission, we'll record it, we'll be happy to do it. We'll also record in the order sheet that we are happy to record it.
No, but what earlier in some cases did, my lord, that was in fact not our submission, but
That order was passed.
But yet, Mr. Chaudhary, even if that is, if that part of the error is rectified, still then those other documents are not proved in accordance with law. Exhibit 4 goes, exhibit 5 and 6 goes. Exhibit
then-
7 is not a admissible evidence. Then there is nothing to conduct. Why this opinion would be bad?
My lord, Annexure 6, page 31 to 33, my lord. In 1970, there is a mortgage deed also in favor of my father's, my lord.
That was not produced.
That is the reason, my lord.
That was not produced in evidence.
Yes, my lord. At that time, that was not available with me, my lord.
That makes it even more
Yes.
dangerous.
Yes, yes. my lord.
Hmm?
Did you go through the records, Mr. Pine?
Yes.
Fix it for admission hearing?
Yes. Notice is not issued in this case, President.
If you notice. Our tenant counsel to the parties issued this. Since pursuant to the orders passed by the court, the tribunal records are available. Matter be listed for admission hearing. After 2 weeks, on a date to be fixed by the registry. We are giving you one more opportunity to convince us.
Any date?
The date will be fixed by the registry after 2 weeks.
Obliged.
Obliged.
Item 3 with 4.
You've gone through the records?
No, Lord.
Fix it for admission hearing. In the meantime, you go through it.
Yes, Professor.
Because
Mr. Uddin,
Yes, ma'am.
we'll keep it for admission hearing.
Yes, ma'am.
Right.
And entry may be continued.
Learned counsel for the parties. Pursuant to orders passed by the court. The tribunal records are available before us. Matter be listed for admission hearing on a date to be fixed by the registry after 2 weeks. Stop. Meanwhile, interim order passed earlier. Will continue. List after 2 weeks.
In both cases, the entry,
Both.
Item 5.
In 4 separate orders.
here also you've gone through the records.
FCR has come as per
Then same order.
lost.
More matter to notice issue for. No? Daily rights since councils are represented. Notice is made. Same orders, notice issued. Respondents come, the notices are waived since they represented. Tribunal records are available. Matter be listed for admission hearing. Interim orders passed earlier to continue. Is there any interim order?
Yes, my lord.
Okay. Interim order. Released accordingly.
Mr. Sharma, you have got instructions from the Home Department to appear for NRC?
Lordship, I have communication made Lordship, but at present I don't have Lordship. Tomorrow or day after tomorrow, Lordship, I will get it.
No, because in all these cases, where we are issuing notice,
Yes, Lordship.
there will be an issue with regard to that non-service of notice on the NRC. That's why.
Yes, Lordship.
So please get it
Yes, Lordship.
by 1 or 2 days.
Item 6.
Here also, you've seen the records? You've seen the records?
No.
That's the same order.
There's the interim order.
You've got a report from the forensics lab?
Lordship, perhaps D not will appear.
Please ask him.
আম্মা গান বলছিল তো
তোমার 15 to 19 এর গভর্নমেন্ট তোমার আনি বলতেছে
না না ইনস্ট্রাকশনটা আনি দিচ্ছে ফরেনসিক অপর কালবার ইস না
Report is not here.
Please find out what has happened. We pass
Yes.
orders after some time.
second half Lordship.
Just a moment, just a moment.
First of March.
First of March.
So report. March.
Non-controversial.
Is the communication. Date of communication. Sending the report. When the report we have first of March. Is 18. Thereby they have improved.
quite different. Which is quite clear second of the
But then we'll have to disbelieve your document because it is non-contemporaneous period of time.
Why did you say that? Another attempt.
If 60 to 80 is applied, only then. Next slide. You see, this is the report. beyond this flag. This flagged document. Mr. Ahmed, unless you give the contemporaneous signature of that period, 1960 to 1980, recent signature cannot be compared with the old signature.
Yes, my lord. My lord, I have no like that signature, my lord. While the signature put in the written statement, my lord, most probably he was aged about 1978 or 76, my lord. Right now his age is 79. As far as school.
But still, the signature can't be compared, so we'll have to.
Sometimes my
can't
lord,
go about
signature
it.
may not be same, my lord. Sometimes, my lord, the signature may not be same, my lord.
No. Look at this report. Signature comparative signature must be contemporaneous age. Otherwise, the forensic says that we can't examine.
Yes.
You must produce any signature of the petitioner for the period from 1960 to 1980. Only if those signatures are produced, then only contemporaneous
Yes, Doctor.
examination can be made.
Yes, stated that disputed signature were present on the document number ration card was written within 60 days, which is appears as per the written documents at the month and the year count. However, the supplied standard signature, signature is 53. For the S3, comparison has been written in the 2018 written statement of the signature, etc. In view of the above, it is not been possible to conduct faithful comparison. Yes, two sets of signature are non-comparative for us. Therefore, definite opinion to be formed regarding the authorship of the person signature E1, A2, A2, and such all the executions can carry. People will get. That's probably.
This ration card is lecture which page?
Page 19, Miller.
19.
19. Are you the picture of the Page 19. Yes, yes. Yes, 43 short. Yes, 43 short, 43. I think I could not mean. I think that's what. Origin which is natural. Origin.
Ready? Yes, Mr. Ahmed.
Milo. Here is school certificate, Milo. Produced by the petitioner, Milo.
Which page?
Page 17.
17.
Who's the Bengali? Who's Bengali?
Mr. Sharma,
Lord,
look at this. The finding goes. It appears that we are more equipped than you. Both. Siddhinath Sharma LP school is a Bengali school.
yeah,
The tribunal has discarded the certificate on the ground that it is an Assamese medium school and written in Bengali, therefore discarded.
yes, yes,
So presumption that it is an Assamese school is without any basis.
yes, Lord.
Now, unless you say that the website
Hmm.
contains a false information of the school by the government.
But this certificate again was not approved by perhaps the authority. I don't know. And we need to we need one school certificate. Is this the email, please? This observation was actually unnecessary. It was not true. Then it cannot be taken into ought not to have been taken.
But Ahmed, even if we reject that finding of Exhibit 2, still Exhibit 2 was not proved by the school.
Similar, when the tender is the evidence of school certificate manual, the as per tribunal order manual case 49, the AGP was absent, therefore cost examination was deemed to be declared. And manual, the debt evidence is
49.
49.
Yes, which paragraph?
Therefore, AGP was absent, therefore cost examination was deemed to be declared. The petitioner adduced the evidence manual, who did a disputed matter. Any school certificate is produced as evidence.
No, but still it's not it's an inadmissible evidence. A document which is not proved by the author, even if there is no cross-examination.
As per Supreme Court matter 2009 SCP. 2009 12 SCP matter 454 matter. After a 2023. When a school certificate is tendered as evidence further, if nobody raised any question, school certificate is admissible as a.
Shows the judgment. Pass
Ah,
on that
yeah.
judgment.
Yes.
Pass on the judgment.
It will be.
Only one.
নামটো কওঁহে
2009, 12 patches.
2009 12 SCC কিমান
454.
454
21 to 23.
Once validity is proved.
Yes, yes. Can be. Could be. Maybe. Most technical cases. It must be proved the judgment as a division bench. I don't think it can happen because this is disputing the paternity. So why can I expect access from the other? Actually, education was in future, 21 to 20. So obviously, that need to be good for you.
Which paragraph?
21 to
21, 20 to 22.
It doesn't do so. That's what you are saying.
Not over. 1 PL.
What is a public document? What is a public document? Here the case was, the validity of the marriage was proved. In the judgment you have relied on, the validity of the marriage was proved.
Their judgment, my lord, school certificate is a public document.
That is because of the fact that the question was that of paternity. So prior to that, the marriage, the validity of the marriage was to be proved. That has been proved. So when the validity of the marriage is proved, the question of who is the father is a consequential evidence as held by the ethics court. But whether it would be a good law to say that merely because a document is proved and there is no objection, it becomes a public document.
Where is that school certificate? Which page?
817, 17.
17.
118.
Page
17.
17.
You see, 17 is invested with the vice of the state emblem.
Yes.
State emblem makes it inadmissible. And please come to section 74. Please come to section 74 of the Evidence Act. A public document is a document forming the acts or records of the acts, number one, of a sovereign authority, of official bodies and tribunals. 3, public officers, legislative, judicial, and executive of any part of India or Commonwealth or of a foreign country. So these public officers must relate to legislature, judicial and executive, and 2, public records kept in form of a private document. So this school certificate, whether it is a public document,
School certificate is a public document, my lord.
no, it's an extract of a public document. The school register may be a record that was never called for. A certificate is merely a copy of the entry made in certain record.
Certain records are collected from the school register.
But that is secondary evidence. That is not a primary evidence. A certificate, what would be a certificate? It must be a information which is recorded somewhere. So that is the primary record. That is the primary evidence. and a public record. School certificate is not a public record.
As per my, my lord, this judgment, my lord, Supreme Court.
No, please don't,
And there is specifically
please don't build
mentioned-
up your case on the basis of a judgment. It must be based on certain facts. That's what my esteemed brother told you. You see, the marriage was proved, and therefore the Supreme Court says that the lady had an access to the husband, and therefore the birth certificate is proved. So even the cross-examination, because the issue of paternity was there, and valid marriage. So therefore, under that circumstances, when the objection as to admissibility of evidence is not questioned, then Supreme Court says that it's
In the other words, my lord, as per Abdul Khalik judgment, my lord, in the evidence, my lord, and the written statement. In the evidence, he stated everything, my lord. That
you
was
see,
not disputed by the.
no,
state
but
respondent.
still the evidence is inadmissible. Even we are thinking in that manner, because you have produced a certificate, and certificate, the author of a certificate is not there. You can't prove the certificate. That's a division bench judgment of ours, not one. There are hundreds of judgments on division bench of this court where that has been discarded,
As well as by Supreme Court also.
Yes, yes.
and Supreme Court has upheld those. Document has to be proved by a author of the document, and that headmaster was never called for. You did not call for the original admission register to show that they were a student of that school.
That was not done.
Because you have to discharge your burden under section 9. Before the tribunal.
So even if that goes, you have not been able to prove it.
The other is what, exhibit 2, my lord. That is
Page?
the family I card, my lord. That was issued in the year 1952, my lord. More than, you know, 50 years. Page 19.
Signature.
Then we'll have to be proved.
Huh?
Then also we'll have to be proved by some- No.
No, they shouldn't have had, okay, here's the one of the things that you got, you put the paper in the- the package is-
Where is the ration card? Page number?
Page 19.
19.
10.
Exhibit 2.
They given number 7.
Yes, Lord.
11, you don't want to do it today. Okay, you're there? Okay. 11? No, 11 is WPC. Huh?
It's not registered as one. No, habeas corpus is registered as WPC CRL.
Okay, 11. Anwar Hussain. Okay, then day after tomorrow. Day after tomorrow then. No, because if it is habeas corpus, how do you come in as a government advocate? No, but then that is not habeas corpus. No, but then habeas corpus is not there. Even the recent judgment of the Supreme Court, it has made clarity because if you know where the body is, then it's not habeas corpus. No.
That you can challenge it. That's a different issue. No, but you are asking for a writ of habeas corpus where the corpus is known.
It's okay. Okay, day after tomorrow. On the both sides are represented. Yes. Okay. Both sides are represented on the prayer made by Mr. G. Shyamalan, the government advocate. Matter stands John today. List on 24. Okay. You just renew that prayer when the matter is reached. Correct. Yeah, please send the trial court record. Okay, let me ask you a question. Somebody goes to the, proves his, let us say, metric certificate. He exhibits a metric certificate or a degree certificate, or say LLB, he has passed out LLB bar registration certificate as a enrollment in the bar. Those documents are proved by someone. Now, to prove a metric certificate, do I have to call for the officials of Board of Secondary Education Assam, or for Bar Council? Do I have to call for the authorities on the Bar Council to come and prove that certificate? No, we'll come to foreigners case again. My question is, A is an advocate. Somebody questions, he does not have a degree. He comes to court and shows two things. He shows his LB pass out certificate issued by Guwahati University, and he also exhibits the Bar Council enrollment certificate. Now, to prove these two certificates, does he have to call for the authorities of the university and the Bar Council?
First of all, Lordship, he has to prove that Lordship, he is the person concerned, Lordship, against whom.
No, definitely. You see, Mr. Sharma, if I am calling for your certificate and you are producing a certificate, we will have to presume that it is your certificate. So we are not on the, we are not yet on foreignist cases. We are asking a general question.
Yes.
Two certificates, or let us say electric bill. In a civil suit, somebody says questions of possession, and one person to prove possession shows electricity bill by APDCL. Say from earlier it was ASEB, now it is APDCL. He proves continuous electricity supply energy bill from 1970 to till date to show adverse position. Now, to prove this ASEB bill, does he have to call for the ASEB people or APDCL people as a proof? So now the question is, in this case, a ration card for a person holding it, that is the original one. It's not a certificate, just like a marriage certificate or a certificate issued from a public record. So this certificate, is this not a certificate of Kuriyar Porisoy Patro? That would be original document. So why a ration card is required to be proved by calling for an authority issuing it? Now, this is a specific question. An extract of record is something else. Like, for example, marriage registration certificate. The original is entered there and you get a certified copy or a certificate of registration of marriage. Then you prove the original one by calling for the records. But if somebody has the original certificate, like say, I said metric certificate or a degree, that is not an extract of public records. My LLB degree or my LLB registration bar enrollment is not an extract of public record. It's an original certificate issued to me. Like say, X wins a carom board competition in school. He produces that. A carom certificate, you can't ask the school people to come and say that in 1978, in class 3, he was a champion in carom board. No, because there are two ways of looking at it. Number one, a document is rejected because it's not proved by the original, by the author. That's one. But here, you will find that the author who has issued it has given only a rubber stamp, deputy commissioner. No, that report is, that's again a question, whether we'll have to accept that as a standard of proof or not. You see, signature or the correctness of this document is not denied. Question number, the proposition number 2, you look at this and understand. I've given this example many times in court. Yes, it is there in the second flag. It's Black's Law Dictionary. I put this question many times. Yes. The word is signature. Yes, there. Signature is a mark of a person. Huh. Yes, also by direction. So therefore, you see, just before the vacation, I could not sign one order. So I told my secretary that while I'm leaving, I can't sign the order, but it has to be uploaded tomorrow. So you put my signature and upload it. So that is with my authority. And therefore, Black's Law Dictionary says that is a good signature. Mark of a person at his person's direction. So therefore, even if my court master puts a signature somewhere and uploads it at my direction, since before 6 o'clock I have to sign, and 6 o'clock was the time when I have to leave Guwahati. So when I put that authority to my court master or to my secretary, I believe it's equivalent to a good signature. So you see, presumption must be within the ambit and scope of section 79 to 92A or 90A of the Evidence Act or 57 of the Evidence Act. You have this. I believe it will be 90A. Yes, it those are the permissible. Because here, if you come to the next annexure, which is a certificate by the ward commissioner, here the ward commissioner has to come and prove, because this is not a certificate which is permissible under the under any act. But when I get a metric certificate, the Board of Secondary Education Assam guidelines, they say that pass out certificate is to be issued. So therefore, that's a certificate issued by a Board of Secondary Education Assam or by a roll of acquaintance of a lawyer, that itself is a proof of the original entry being made. That's why we say this certificate has to be proved. So exhibit 3, if you can discard it, you can discard it. But to discard this ration card, family identity card, that is something we are questioning. All right. Citizenship Act or এই তো ধরো, ঠিক। document presumption that he is gone back. If that was then the citizen is required to maintain document of continuous residence. Only means for 15 years coming. Because then, Mr. Sharma, there would also be a supplementary question. You see, if somebody is a foreigner and has come into India, then he has to show continuous stay. But here is a case where somebody is saying that in 51 he was already there in the country. So question of a presumption that he has come from a specified territory is not there. Presumption that he has come from erstwhile East Pakistan is also not there. Therefore, for the tribunal to say that he has gone back to Bangladesh, and then that apart, the second supplementary question would be, you see, the tribunal passes an order that cross-examination is declined. That means if an objection to admissibility of a document is taken, as a witness, you may take an adjournment and try to supplement it by an evidence, admissible evidence. So in tribunal, how it proceeds, we don't know. In a suit or in a suit or proceeding, criminal proceeding, if inadmissible document comes, then you still have a way to rectify it. And if you don't, then there is a presumption against you or any witness. But if admissibility to the document is not taken at an earlier stage, then to discard it by saying that the document is inadmissible in evidence. Definitely will cause a prejudice. You see, you had posed a question that this court had already issued a direction and then had the signature compared. Now, if you go by the legal definition of signature, that inquiry may not be required at all. If the signature is not in dispute, you did not ask the witness that this is not your signature. He could have put that signature. Because today, if you challenge one of my orders sitting in singly, if you challenge my order by bringing a copy of my signature given in the bank account, definitely it will not match. In my bank, I use a different signature. Now, if that is brought to the notice of the court as sitting singly, and then you say that your signature in the order varies from the signature you are having in your bank, would it be an admissible objection? Because after I have put my signature, the courtmaster, sorry, the secretary uploads it. The courtmaster verifies it. It goes to our registry, and our registry has my sample signature by which it can be compared and say that this is an authentic order passed by the court. I'm taking out a single bench incidence example because when I'm in division bench, my brother's signature is there. So that is an additional proof that both of them have signed. But what happens when I sit singly and sign, and that signature does not match with the one I have in bank? Then what happens? Will you say that the bank account is of an imposter, or you will say that the signature of order, signature on the order is by an imposter? Both are not tenable because a signature for one purpose may vary with another for different purposes. I use different signature. In passport, you'll have to give full signature. And therefore, to avoid because what is a certificate has been defined in one of the cases I have read from Honorable Justice Bujar Barwa, as he was then. He had This is the evidence. Usually, that was the one of the- This is the-
Home saving is
We're just brushing up our case laws. Just a moment. We are giving an opportunity to the state to show us from any record or any act, rules or orders that family identity card is an inadmissible document
In itself.
in itself. I give you an example, like my metric certificate or LLB certificate, lawyer's enrollment certificate from the Bar Council. All these types of certificates, which we consider, we are thinking it should be considered as an original document. For that, is there any act, rules or notification or any orders like Assam price control order, which says that a family identity card is itself not a admissible document unless the original is produced? So there are only two things we have found. If a document is otherwise admissible, then objection has to be raised. But even if a document is itself is inadmissible, like for example, the school certificate. School certificate is not proved by the headmaster, can itself without even objection being raised be rejected. There are many authorities,
Yes,
we have
yes,
checked,
Lord.
there are many authorities on the point. But can a ration card be termed as an inadmissible document? We'll take it up on Friday,
Lord.
correct? By that time you'll be able to do it.
Yes, yes,
Assam
Lord.
price control order, you can check it up,
Yes, Lord.
because family ration cards are issued under that only.
Yes.
Assam price control order, I think. Assam foodstuff distribution control order is noted down.
Assam.
Assam foodstuffs distribution control order.
Order
1958.
19. Otherwise, Lordship, there are so many decisions, Lordship, regarding that, Lordship. A documentary evidence would have to be proved on the basis of the record and the
No, that's what we are asking you to do, show us. Because a certificate itself
Yes.
is a certificate. You don't have to call, I don't have to call persons from the bar council to prove my bar enrollment certificate.
Yes.
I'm not required to call. It in itself is a admissible document. Anything which is an extract of a public record, yes, I can accept your contention, but not otherwise. Hmm. See, later. Lesson number 1. In short, number 1. No, different. Second.
In normal time, I come in identity. But what only produce evidence. Even if it is maybe there could have been a different way that we would not feel the produce that what it is. But it's is a study evidence required proof.
Because it is a certificate. It's not a very good but it's given a certificate. It's not an extract. 61. Another evidence. 62. Final evidence. Chalan. Chalan, certificate of. Right. Treasury. Bank of. Everything is in Amazon. Conclusion, 62%. When it is in counter, every counter orders is. Proceeding. This is an opinion itself. Mr. Sharma, Friday would be okay? In all sides are represented. Next, in course of deliberation, the learned Mr. G. Sharma, a government advocate, appearing for the FT matters, has supported the opinion impugned in this writ petition in respect of the finding recorded against Exhibit 2, which is a family identity card. And has submitted that the rejection of the said document cannot be faulted with. Next paragraph. Therefore, the learned government advocate shall address the court on the next date of listing on the point as to whether the family identity card within bracket Orial Porisoy Potro in vernacular, SMS vernacular, close, is an admissible primary evidence. Or the said document can be said to be a extract of a public record which is required to be proved by calling the original records as well as the official from the establishment which has issued the said family identity card. Full stop. That's absolutely. Next paragraph. As agreed to by both sides, list on 25/10/2024. You wanted to say something?
Lordship. Yes, Lordship, I only want to read few lines from our High Court judgment, Lordship.
Yes.
Yes, Lordship, in so many judgment, Lordship, that line was quoted, Lordship. Yes, Lordship, it is tried that documentary evidence would have to be proved on the basis of the record, and the contemporaneous record must substantiate and prove the contents of the document. Proof of document is one thing and proof of content is another. Not only the document would have to be proved, but its contents would also have to be proved. That apart, the truthfulness of the contents of the document
doesn't take us anywhere, Mr. Sharma.
Lordship.
You see, because from the evidence it is said that I have an identity card which is issued in the year so and so.
Yes, Lordship.
Correct. So contents is proved. We don't want the how many kgs of what you call atta dal chawal somebody has lifted. That is not the primary investigation we are doing. The investigation we are doing is whether he is a person who is entered India prior to 25/3/1971. That is the inquiry. So in respect of that, the evidence is there.
Yes.
So now the question, that is why we have framed our question very carefully. Please listen to that and go through it. The question is because whether the family identity card itself is a primary evidence or not. That's why we asked you specifically to read the 1958 order. Although we have bought the book and read it, but still you'll have to do some exercise. Do it. Try to have your own interpretation. Because every document you can't say that the document has to be proved by calling contemporaneous records.
Lordship.
Because then what would happen? Let us say that there is a land dispute. Somebody brings a pata. And then you say that as per this judgment, we have to prove it through contemporaneous records. Now, please tell us what would be a contemporaneous record for a pata? What would be a contemporaneous record for a jamabandi? It leads to many facets being rendering questionable. To what extent we would insist on our contemporaries records? All these records, you please check up in which context it is being said. What is the context of this record?
Regarding Gaura certificate, Lordship.
Then Gaura certificate is, we all know what is it. So Gaura certificate, you can't place that ratio for a family identity card. Because if you ask me, what is the contemporaries records of your lordship passing out your metric examination? I would have none. I would have my mark sheet and my what you call BSL, what you call Board of Secondary Education Assam certificate. Contemporaries record would mean the result sheet, which I don't have. say in the absence of contemporaneous records, can you negate this metric certificate itself? Say a birth certificate. The birth certificate you prove. How do you prove a birth certificate? You prove that certificate. Now, for every proceeding, if you have to call a government official
Yes, sir.
to prove contemporaneous records, would mean that one of the official of every department would be in the court giving evidence for contemporaneous records. Birth certificate, contemporaneous records, you will also require the hospital certificate. If somebody is born at the home, now please tell us what would be a contemporaneous record of somebody giving a childbirth at home. And I know name of one person at least who was born in aircraft. And because of that, he is a citizen of US. Because by that time, the flight was within that, it was in a, what is it, right?
Airspace.
No, it was a US Airlines. I forgot the name. And it was within the airspace of USA. And therefore, Indian child is a US citizen. So what is the contemporaneous records? That's why we have put a specific query. This document, whether it needs a contemporaneous record to prove it. That's the only query we have for the time being. Next.
Item 9.
This statement has been called for matter. And
yes,
against the expert order.
ex parte.
I just come by.
How much was your default?
Default matter, I have asked for time to file a intent statement matter, but I have not given time matter. Do I?
No, a lot of time was given.
Ultimately, I asked for.
A lot of time was given, not one. Fixed on 12/12/2014, 2/1/2015, 8/3/2015, 8/5/2015, 15/6/2015. And then ex parte was fixed on 15/7. So you got 7 months time.
Yes. I pray last month maybe given to me when I had intent statement.
No, you'll have to show us a convincing ground.
I look at my.
You have to show us a convincing ground. The opinion is of 2015. You have filed this reparation in 2021. Why should we entertain that?
But after before judgment, I could not able to know about that. When police came to my house, my lord, then I could know it that they are the expert I have stated in my lord.
No, you see,
paragraph
number
four, my
one,
lord.
you take two plea. Number one, you say that you are a day laborer.
I could not appear, I could not.
That's
contact my
okay.
client, my
You
lord.
are a day laborer.
Because I
And
have
second,
to
you say
read
that you
it.
could not engage a counsel. That
So
means
when
the
police came to my house, then I could know it.
No, no.
The expert has.
no. You see, these two forms an admission that you know about the case. You were served with a notice. You take a plea that you are a day laborer and could not engage an advocate. That means you know that you have to engage a counsel and appear before the tribunal. So that's an admission. Number two, you also know about the proceedings in 2015. And then you wake up in 2021.
Yes.
You
I
say that the
admit my
police
fault,
came.
man. That man, anyway, but I may be given one chance.
No,
to
no.
put
It
up
can't be
a
for an
fight.
asking. Mr.
Let me have time to.
Mr. Mohammed, you know more than us.
I have a good case, man, because when I submit matter, my brother, my father, my grandfather were, they are Indian citizens, but I made a foreigner, declared as a foreigner, You know, I will given one chance, I frame, that is needed. I will submit my document, It is a fault on me, I admit.
No, you see, we are bound by the precedents of this court. There are many judgments which say that it can't be from mere asking. Your default must be evident that your default is for a reason which is beyond your control.
For any similar type of cases, my honor, our High Court, and given some other persons, because I have similar type of cases.
And what do you say about the old saying, good things must come to an end?
My lord, may I pray, just my.
No, let us see that judgment you are referring to.
Yes, sir.
Pass it on, Mr. Das. Hmm?
My lord, I have no other option but to pray lordship only to file recent statement. I admit my fault was there on me, on my part, but my lord, I could not submit my defense, Let me have on time to submit my defense,
Because people who can't, people who can't afford day laborer will not come to you, they will go to Mr. Biswas. Yes, Mrs. Sharma, what is your comment on this after reading this judgment?
I have given. I have seen lordship.
What is your submission?
After passing of this judgment, lordship. After passing of this judgment, lordship. So many judgment has been passed, lordship, by this honorable court. At present, I don't have the copy, but lordship, by imposing some cost, lordship, a petitioner was allowed to contest the proceeding, lordship. The lordship, my humble submission is that lordship may allow it, but some cost may be imposed. Otherwise, same thing will repeat again, lordship.
Give it. Mr. Mr. Noor Mohammed, in this case, what is the document to, for you to connect to your father?
I have the document, my lord, that my father, grandfather, my
That is
brother.
okay, but what is the document to connect you as your, to connect you to your projected father or grandfather? How do you connect yourself to your father and projected grandfather?
My lord, your lordship, see, my lord, that is a certificate of the office of the secretary of Municipal Dow Concert.
Page 30, we have seen that. Page 30, we have seen that.
I got married in 2004. And I have, my lord, cut my vote on 2005. That my lord, my brother, my father, my grandfather have my lord, casted their vote, my lord.
No, that's, you see, this is a certificate. It's only a supporting document. Read the footnote at page 30. It's only a supporting document, but this doesn't become an evidence. So except for page 30, you have no document to connect you to your father.
My father was my lord, never could do my lordship, chief my lord. Page 44, my lord. Page 44, my lord, I casted on board my wife of as a Homer Roman. And Homer Roman is my husband, that is my.
No, that is not a
marriage certificate. my lord.
No, that is not that is not a document of prior to 1971. So the only certificate which connects you to your projected parents is page 30. How do you support this document?
My lord, that is already documented, my lord. Here was my page, There was a page 27, my lord. Page 27, my lord. Mumtaz Begum, daughter of Kudus. Father, of village so and so. I got married with a Weaver Roman. This Kudus, my lord, here custody both my lord. My lord in 70 of my lord. Lordship, my lord, page 25, my lord. Page 25 certificate, my transfer certificate, that is my lord. The original page, my lord, page 26, my lord. Certified that Mrs. Mumtaz Begum, daughter of Kudus, in evidence of so and so, James Miller. That is, he is my father, Kudus. Kudus, my custody is what my was earlier made. So before 70 also made.
You don't have a kabinama for your marriage. You're relying on only a Kompura certificate or a Panchayat secretary certificate. That means you are not married in accordance with the Mohammedan law.
His title matter, grandfather and the father matter, they are custodian for 1965. This is the father and Abel Hussain is their grandfather. Thereafter also matter, in 70 matters, 70 also they custodian for matter. Father and grandfather of the petitioner.
Mr. Mohammed, you know more than us. Voter list is not a proof of lineage. It's not a, it does not establish. There must be something, some other document.
I will try matters. Then I will be given some time and I will submit to.
Because in this judgment also, which you are relying, there's a observation of the trial court that it is prima facie satisfied that there are documents to prove citizenship. But here we are not finding one. All these documents are 2015. And in 2015, you have documents and you don't go to tribunal. All these documents are 2015. But then you don't go to the tribunal. You allow an ex parte order to be passed. Heard. Mr. S.K. Nur Muhammad, learned counsel for the petitioner, also heard. For the Union of India, who is there?
Mr. K. Gogoi.
Mr. K. Gogoi, learned CGC appearing for respondent number 1. For Election Commission, you're there, Mr. K. Kuli. H. Kuli, learned counsel appearing on behalf of Mr. A.I. Ali, standing counsel for respondent number 2, Mr. G. Sharma, learned standing counsel for FT matters, representing respondent numbers 3, 5, 6, and 7. Next para. The respondent number 4 is unrepresented, however, as state, as the coordinator NRC, is an authority under the Home Department of the state comma the respondent number 4 is deemed to be duly represented. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, comma, the petitioner, namely, take the name from the constitution, namely so and so, has assailed the ex parte opinion dated 15/7/2015, passed by the learned tribunal and the learned member, comma, Foreigners Tribunal, comma, Nagaon, first, numerical 1 ST, comma, Nagaon, in FT case number 5060 of 2012, comma, thereby declaring the petitioner as a foreigner. Who has entered into India on or after 25/3/1971 and not an Indian citizen. Next paragraph. The learned counsel for the petitioner has submitted that though the petitioner has received notice of the proceedings, comma, but due to her poverty, she could not engage any counsel due to acute financial distress. Nor could she appear before the learned tribunal, although sufficient time was granted for her appearance. Full stop. By referring to the documents annexed to this writ petition as annexure C, capital C, TO2, annexure M, comma, it is submitted that the petitioner has several documents to show that she is a Indian citizen and not a foreigner. Full stop. Accordingly, comma, it is submitted that if the petitioner is given one opportunity to appear before the learned tribunal to prove the said documents, comma, the petitioner can legitimately, petitioner can establish that she is not a foreigner. Next paragraph. The learned standing counsel for the FT matters has submitted that though the explanation for not appearing before the learned tribunal is vague, but the prayer of the petitioner may be allowed at a cost. and that a strict timeline be framed for an expeditious disposal of the matter, which is a reference registered in the year 2012. Next matter. Under the circumstances, as indicated above, and taking note of the submissions made by the learned government advocate, comma, we are inclined to allow this petition by granting one opportunity to the petitioner to appear before the learned forensics tribunal to prove her citizenship on full stop. Accordingly,
So
for the same continue, for the purpose of enabling the petitioner to appear before the learned forensics tribunal for a fresh examination of her case on merit, the court is inclined to set aside the ex parte opinion dated 15/7/2015 passed by the learned member, foreigners tribunal, Nagaon first, Nagaon in FT case number 5060/2012, subject to the following directions. Then give it ABCD. A. The petitioner is directed to appear before the said learned tribunal on or before 14/11/2024 next B. On the date of appearance, the petitioner shall file a written statement and also submit all the documents on which she intends to rely to prove that she is not a foreigner. Then next paragraph, AB is there, then next paragraph, numerical paragraph, next. It is further directed that, it is further ordered that in the event the petitioner fails to appear before the learned member, foreigners tribunal, Nagaon first, within the time allowed, the ex parte opinion dated 15/7/2015 no, I'm sorry. This order shall, don't write that. It doesn't appear within so and so, this order shall lose its efficacy for non-compliance of the directions. Full stop. Resultantly, the ex parte opinion dated 15/7/2015 passed by the learned member, foreigners tribunal, Nagaon first, Nagaon in FT case number 5060 of 2012, declaring the petitioner to be a foreigner shall stand revived. Next paragraph. Mr. Sharma, we direct the deposit of cost to be before the tribunal,
Lordship, District Legal Service Authority, Lordship.
District Legal Service Authority. Okay. District Legal Service Authority, Nagaon. Okay. Next paragraph. We are further inclined to impose a cost of ₹10,000 on the petitioner to be deposited before the District Legal Services Authority, Nagaon, within 14/11/2024 and to produce receipt of such deposit before the learned foreigners tribunal. This will be C. This part, cost will be C. Next paragraph. Since the citizenship of the petitioner has come under cloud, the petitioner will appear before the Superintendent of Police within bracket border, in brackets Nagaon, and furnish a bond of ₹5,000 within bracket in words ₹5,000 only, bracket closed, with one local surety of like amount to the satisfaction of the said authority, whereupon the petitioner will be allowed to remain on bail. Full stop. The Superintendent of Police within bracket border, bracket closed Nagaon, shall also take appropriate steps for capturing the fingerprints and biometrics of the iris of the eyes of the petitioner, And shall also record all the particulars of the place of residence and other particulars as may be required to secure the presence of the petitioner before the learned tribunal. Next paragraph, with the aforesaid observations and directions, the present, this petition stands allowed. Next, the records of FT case number 5060 of 2012 be returned forthwith to the concerned tribunal. This is the copy. Earlier order, you take help from that.
Item 46, time being.
Order at page 73.
Page
Page 73.
73.
Second minor is criminal minor petition declared surveillance, husband and wife minor. In the High Court minor, Honorable High Court declared the husband minor to obtain a second opinion, but minor not in case of wife. Wife also submitted some document. Minor, for second, the time of second opinion minor, case of wife was not taken. In such manner, the husband for the second time declared to be Indian citizen and wife is foreigner.
No, you see, if a prayer is allowed in respect of petitioner number 1, it is deemed that the petitioner number 2's prayer was rejected.
That is why minor review petition.
No, because you see, the citizenship has to be considered in a different manner, not as husband and wife, but as a son of an Indian citizen and a daughter of an Indian citizen. So you'll have to show your Indians that your father was an Indian citizen, not your husband.
Yes, ma'am. Right. Right,
So,
ma'am.
but that if the prayer not allowed is deemed to be rejected.
I submitted a voter list of 1966 of my father, and 71 of my voter list of my father. But only the difference, my father used to write title Sin minor. And subsequently, he used to write the title Sarkar. That is the reason, my lord, why I was not declare Indian citizen. Exhibit A and exhibit minor O, exhibit P, exhibit Q. These 4 documents, my lord. Exhibit N is the voter list of 1966 of my father, Mahendra Kumar Singh.
But Mr. Chauhan, come to page 77.
77 is
Yes, in 77, in the second last paragraph, the court has recorded reasons why it did not accept the contention of the petition number 2. In respect of petition number 1, the contention was accepted
Yeah.
that the ground assigned by the tribunal for rejection only being post 71 document is not reasonable and justifiable. So that is why the husband's case was allowed, not the wife's case.
Not on the, now, my lord, not in the case of the husband, because already.
No, you see, there's a finding here. Please come to page 77, last paragraph. As regards petition number 2, we find no good reason to make interference. So it's a finding on merit.
But
We can't review the order.
But my lord, my voter list of 1966 of my father was.
No, we understand, but in review, we cannot change our decision. We can merely correct the arithmetic errors and other things, but we have given a finding of fact. The petition number 1's case is accepted, and petition number 2, wife's case was rejected. So we can't allow, we can't exercise review jurisdiction and
Children, my lord, their case also allowed by my lord tribunal. Subsequently, the second.
no, that we can't say. Well, we can't say we are not exercising jurisdiction on that. But the fact is that you will claim, you as a wife will claim lineage from your father. And that is an evidence we found not acceptable.
Voted for my lord. My lord, the voter list of 1966, it was not believed. But only reason, my lord, my father earlier, I used to write my lord seal, because they are from Barbar community. Subsequently, he used to write his title Sarkar, that is the reason. And for that, my lord, I submitted affidavit to the court.
No, those were considered. Each and every document you gave was considered at page 77.
The error apparent.
You must show error apparent.
What is the error in the judgment?
My lord, I'm for, my lord, only reason, my lord, but I submitted the voter list of 66 and then I was 71. And my lord, according to petition, my lord, there should be considered, it was not considered. And such a situation, my lord, husband in India, her wife is not.
Possible. But for in a review jurisdiction, you could point out the error on what basis do you recall the order? Some error apparent.
The second opinion also, my lord, is page 79. My lord, court below not considered because, my lord, because the observation of my honorable high court, this is why the case of the wife was not considered in the second opinion.
Rightly so, because principle of res judicata will set in. Principle of res judicata would be there, will be applicable.
Because of my lord observation by honorable high court, that is why in the second time, my lord, the tribunal not interfere. Only in case of my lord husband.
No, correct, but what is the error in the judgment? What you are urging is apparently a mistake in the order, which you have to challenge before the appropriate manner.
Only my lord, that my lord, my father was considered. If it would have been considered, the result would be otherwise.
That would not give us the ground for review. Mr. Chauhan, you'll have to address us on the parameters of review.
You can rehear the matter, because you say that it requires certain corrections which is apparent on record. From the submissions you are making, it appears you want us to reappreciate whatever has already been appreciated. Can it be done in a review?
My lord, this petitioner.
You see that the issue of Sheel and Sarkar was considered earlier also. The issue regarding the documents, insufficient documents to show.
In first opinion, my lord, husband and wife both declare foreigner.
No, we are not on that. What happened first or what happened second, we are not on that. We are trying to find out error apparent on the face of record in a review jurisdiction. What is error apparent on the face of record?
My lord, petitioner treated my lord, the second time, perhaps my lord, the petitioner we had considered, but my lord, because of the question of honorable high court, my lord, the tribunal not in.
That does not become a ground for review.
Is there any error in the observation of the High Court? Point on that in respect of.
My lord, certainly I cannot challenge that if anything is there, my lord. Certainly I have to approach the highest court. But my lord,
No, we don't know where you can approach, but we can't say that. But definitely, if it's not an error apparent on the face of record, your issue is that it was written as Seal, then Sarkar, that was addressed. The insufficiency of the documents to prove your Indian citizenship, that was addressed.
for my lord, for the second time, my lord, second time when opinions of my lord, I thought that under impression that perhaps the case of the petitioner also being considered by the, will be considered by the tribunal. But tribunal, my lord, not enter in that because my lord observation by honorable high. It is the limitation of the petition.
Bound to be that hard difficulty because High Court has already given a finding.
You have rejected it. You have considered it and rejected.
Rejected, but in case of husband, my lord, second opinion, my lord.
Husband was not rejected. Husband was found justifiable. There is a finding recorded, not reasonable or justifiable.
My lord, is page 77, last three lines, my lord. Second opinion, my lord, this was for second opinion. On the above, we are of the considered view that the tribunal is required to pass a fresh opinion in respect to the petitioner number one. It is the limitation, my lord.
You know, because of exhibit C, D, and E.
Yes, yes.
Now, C, D, and E, does it support your case?
My lord, there is two parts. One part was the for the husband and second part for the wife. That is the petition.
The finding of the court is that the tribunal is required to pass fresh orders after consideration of exhibit C, D, and E. Now, what is C, D, and E is reflected in page 76.
My lord, regarding my lord husband.
Then what benefit are you going to get? Or from C, D, and E?
My lord, the documents submitted by petitioner only, my lord, the NOPQ.
Mr. Chauhan will be dismissing it, will pass orders in the chambers. We don't have time. List it tomorrow. For passing orders. And for necessary orders. Yes. Pardon me? No, I see. Okay, so you are saying that the present petitioner is a co-accused, and for other co-accused, I have passed an order. Okay, okay. Huh? Transfer to CBI. Then you'd have to impede the CBI in this bail application. Mr. A. Chaudhary, learned counsel for the petitioner, has submitted that as a co-accused was granted bail by this bench, comma, this matter has been listed before the same bench. Next para. Mr. D.P. Goswami, learned APP, has produced a copy of notification dated 9/10/2024 to project that pursuant to the provision of Section 6 of the Delhi Special Police Establishment Act, 1946, the Governor of Assam is pleased to accord consent for transfer of the investigation of Nagaon PS case number 859 of 2024 under section 61 within bracket 2 comma 316 within bracket 2 comma 318 within bracket 4 of BNS, 2023, and section 21 within bracket 1 comma 21 within bracket 2 bracket close comma 21 within bracket 3 comma 22 and 23 of banning, BANNIG, banning of unregulated deposit scheme act, 2019. Full stop. A copy of the said notification is made a part of record. Next para. The learned counsel for the petitioner 6. You want to refile it or you want to amend it? Huh? No, I is not required because we'll permit you if you want to amend it by hand. But do you have to make corrections of the cost title? Okay. Next, on the prayer made by the learned counsel for the petitioner, is permitted to implead the Central Bureau of Investigation represented by its public prosecutor as respondent number 2. By renumbering the existing respondent number 1 as existing respondent as respondent number 1. Full stop. Next para. Accordingly, the learned counsel for the petitioner shall submit a fresh cause title to the AOJ. Bill कुछ जगह 10 bill will be which section? AOJ, criminal appeal section would do the needful, and thereafter matter be listed before the court. Huh? No, you have to give it. Once it is done, they will list it immediately. No, that we don't know. That we don't know. Once you do it, if you can do it tomorrow, it will come day after tomorrow. You do it. Okay, next para. Once the implementing is done, the registry shall reflect the name of PPCBI while listing the matter next. Which one? Okay. Okay. Mr. A. Chaudhary, learned counsel for the applicant, submits that there is a mistake, a typographical mistake has crept in the bail application and in the connected bail application being BA number 2414 of 2024 and in place of Nagaon PS case number 559 of 2024, the same is required to be struck off and substituted by Nagaon PS case number 859 of 2024. Full stop. The prayer is allowed. After hearing Mr. D.P. Goswami, under APP for the state. Next para. The learned counsel for the petitioner, applicant, is permitted to make necessary correction of the case number in the connected AB 2414 of 2024 under his signature, and thereafter the matter be listed before the court. Okay.